Hey everybody. Hello, 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 hello. I got to make sure I had my water with me. Good afternoon, everyone. Everyone wanted me to come on live and do a reaction to what happened. I be having stuff on my glasses all the time. Look at this. My glasses stay dirty. Hold on a second. Yeah, I always have to clean these things, man. It's just a pain in the butt. Just hold on a second, y'all. These glasses get on my nerve. Everlasting nerve. So I have to keep these glasses cleanser wipes all over the place because I just pick glasses. Glasses are no fun. Always messing up. Just bear with me a second. Just bear with me a second. Gotta get the wipe and clean. Mr. Clean, Mr. Clean. Just hold on a second. Just wiping them. All right, here we go. I think I can see better than. Yeah, there it is. There it is. I can see better now. Do you see? It's cleaner now, right? All right. Sorry about that. I had to get my glasses because I saw something on it from the video. All right, y'all. I wanted to go over some of the stuff that was inside the exhibits for love and what was said, and I'm gonna go ahead and I'm going to read. I'm going to read. So anybody has a problem with my reading, go ahead and leave now because I'm going to read. But before I start reading, I'm going to show you guys the video of when she said Melnick was communicating with what? Gunna arrested in Belgium? Alex, did you just say that? You said Gunna got arrested in Belgium? Can we get into it immediately? If you're in a rush, you probably need to go ahead and leave because what you're going to do, you're going to make me prolong the time, okay? Talk about, can we get on with it quickly, please? No, and they didn't even say please. They said, can you get on with it immediately? You better go find someplace else to do that with. Will you be on Nick? No, I won't be on Nick's panel because I'll be with Big Jeff on I'll be with Big Jeff on Friday. Yeah, he has a podcast. I'll be on there with Big Jeff. But tonight I'll be with Woke Christian. Hey Denise. Oh, okay, okay. I thought you was trying to go in on me. Okay, okay, okay. I'm sorry. 401. 504. I apologize. I have that ready. Y'all know. Alex just said that, Gemini. Okay, let me go ahead and do what I need to do. I'm gonna be on woke Christian. Okay, let me go ahead on and show what I need to show because I have people who's on a timetable. I'm getting all the defense and I don't need to be on the defense. Okay, let's go ahead on. First, I'm going to bring up first what she said in the paperwork, right? She mentioned the link of when supposedly when Melnick spoke with the counsel. Look, it says, after motion hearing, the court recessed for lunch. During the lunch hour, Mr. Melnick spoke with counsel for the defense, but at no time attempted to communicate with the state. After lunch, the jury was called in and Mr. Copeland took the stand. Mr. Copeland cheekily answered a few questions, and when he asked his age in years, Mr. Copeland responded, I plead the fifth. So we're going to go ahead and click this link right here, and we're going to stop it right here. Okay, and we're going to play it so you guys can see what she's talking about. Hold on. And it's right around the 422 mark that she's talking about, okay? We're going to go ahead on and share it right now. And I'm going to open this up for you guys to see what she's talking about. All right, let's go into it right now. Let's go.
Okay, all right. Deputy Ham, can you check on our jurors, please? Mr. Steele, what can I do for you? Okay, all right.
John, just a reminder, issues with the exhibits. I don't know if the state's playing that today, but I just wanted to give you a heads up.
It's at the 422 mark, y'all. 422 mark. It's going to come up in a minute.
She said you'll deal with it. She'll deal with them as they come, as they're introduced. So
now look at love. Look at love. Hold on.
all right.
Okay, you're going to look at love, right? Look at love right around the 422 mark, right? Look how she looks over at Melnick. You're going to see Melnick say something to Steele. Melnick sits down, and you watch Love shake her head, okay? Y'all pay attention, okay, at 422. Let me bring it a little bit closer so you guys can see it a little bit closer. Hold on. Now, hold on. This is before they sit down. Hold on. I think it's right around this time, right before she sits down. Hold on. Let me see if it's right around here. Hold on. Might be then. Hold on a second. Let me get the timestamp. Hold on. So I want you guys to see it for yourself, what she said when she did that. Okay, so 422.25. 422.25. It's going to be right around. Why does it jump to? Wait a minute, it jumped. It's supposed to be 422.25. Why did it jump? Y'all, did they remove that? I was just looking at it this morning. Hold on. Did they remove it out of the video? It jumped. Look. See, it jumped to, hold on, let me see. It jumped. Watch, hold on. Watch, y'all. Because it's 422.28. We want 422. That's 27. 24. 20. Let's see. Okay, there it is. It's coming up now. Okay. All right, y'all ready to look at this? I had to make sure I had the right spot. It's 422. We're at 422. It's 422.25. Now take a look at her. Let me move out the way. Hold on. I want you guys to take a look at this, okay? All right, there we go. Take a look at Love. Take a look at her, how she looked over at Melnick talking to. Let me move it up a little bit. Hold on. Go ahead and let's look at it right there. All right, look at it.
We know where you are.
All right.
Okay, now take it. It's gonna scan. Okay, it's gonna scan over here, and you're gonna see Melnick talk to Steele, and then he sits down and watch Love's face afterwards. Okay, I had to stop it for a second. Okay, look at over there. Look in the corner where you see Melnick talk to Steele. Okay, you already seen Melnick talk to Steele. In a minute, hold on. You see Steele going over there talking to Melnick. Hold on. Ready? See Melnick, say something to Steele. See Melnick right there in the corner? Say something to Steele. Y'all see it? And then turn around, look at Love, and we'll see what Love do, okay? Y'all guys see what I'm talking about? Let me see if y'all, hold on. Do y'all see what I'm talking about? Okay, y'all see what I'm talking about? Y'all see it? Okay. Now you see Melnick in a corner talking to say something. This is right after he, this is during lunchtime when they're coming in. This is when they're coming in. He came in through that door. And he says something to Steele a hot second and then sits down. Okay? We're gonna play. Hey. Y'all know don't try to tell me what to do now. Because what you're gonna do is get me just to sit there and not do it. Okay? Because y'all didn't even know anything about it. So calm down. Calm down. Calm down. Lord have mercy. Because if y'all was gonna be all like that, y'all should have went and found it yourself. Okay? Let's not do this. All right, watch this. All right, here we go. You see Melnick talking to Steele. Hold on. Ready, set, go. Now watch Love. She flipped over there. Love is looking over there.
All right, ladies and gentlemen, please be seated.
You see that? She looked over there.
All right, thank you, Deputy Ham.
She shook her head. Y'all saw that, right? Did y'all see that? Did y'all see that? But listen what she said. Look what she said. She didn't say that on her when she talked to the judge. This is what she said. Remember, she said that he shrugged his shoulder to the defense. Now, he didn't do that. Okay? All right, let's go back.
Ladies and gentlemen, the jury, good afternoon. All right. Without further delay, we're going to go ahead.
Did she see? You see how she rolled her eyes at us? The media? Did you see how she rolled her eyes at us? All right. Should I replay that again, y'all? Okay, here we go. Let's play it again. All right, here we go.
Waiting on one of your honor.
All right, sir.
She was talking about at the podium, but look, this is it right here, look. She wasn't even looking when you see, she wasn't even looking when Melnick was talking to Steele. You see that? She's gonna turn around now. Now she turns around.
All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. Ladies and gentlemen, the jury, good afternoon. All right. Without further delay, we're going to go ahead and call the next witness.
She don't look at us. Look.
Ms. Hilton calls Kenneth Copeland to the stand.
All right, summon Mr. Copeland, please.
Okay, now I'm going to give you a little bit of backstory behind this. This is after lunchtime. This is when we saw Woody doing in the hallway, because remember, he was in the hallway and Woody was on the phone with somebody and he was telling them that at that time that he was going to plead the fifth. This is when the deputy was around. All of us was in the hallway. All of us. Every single body was in the hallway. Woody was on the phone. He was walking, pacing back and forth. And this is when he also mentioned about him taking the plea, the fifth. Not plea, but the fifth. Okay? Everybody was aware of him taking the fifth. This is when they also pulled myself and George Cheedy and the camera person. And told us not to record because if Woody takes the fifth, we cannot record. Okay? So everyone was aware that he was about to take the fifth. Okay? So.
Your Honor, here's that. Mr. Copeland is.
Your Honor.
Here it comes. All right, Mr. Copeland, go ahead and approach the witness stand. Before you sit down, if you would turn and face Deputy Hand and be sworn as a witness.
You swear affirm testimony to everybody get reported the truth, the whole truth, nothing but the truth, so.
Yes.
You maybe see, you state your first and last name with the spelling of both, please.
You say that again?
State your first and last name with the spelling of both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor, pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
Kenneth
Thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Well, are you gonna let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, for the jury.
All right, ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
Okay. Now this is when they take him in custody, right? And then Love comes back after Steele do his motion. This is what Love said. Let's go back. Let's go play this part. Okay.
Knowingly let a witness invoke their Fifth Amendment privilege.
Okay. This is what Steele said. Because remember, Steele mentions about them knowing that he was about to plead the fifth, which we all knew, everybody knew in the courtroom. We all knew. That's a fact, guys. A fact. Because George and I and the camera person was told already that do not record because when he gets arrested, they do not want it to be shown on the camera. Okay? Now this is Steele coming up to talk to the judge about what basically happened. Oh.
All right. State, do you have any other witnesses you plan on calling this afternoon?
No, Your Honor.
Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
And then, Your Honor,
the jury is excused, would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
Okay, this is it. Now listen to what Steele said.
And what's the basis for your mistrial? We
Listen.
didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him. He only had was.
Okay. Now, the judge says we didn't know that he was going to invoke. We didn't know what he was going to testify to. That's what the judge just told Steele. And did Steele say anything prior to that? Hold on a second, because I think the judge jumped the gun on that. Hold on, let's see if Steele mentioned to him that the witness was invoked the fifth. Let's see what Steele had said. Hold on.
Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
And then, Your Honor, the jury is excused. Would you please entertain a motion for a mistrial?
Okay, he's saying if the jury, blah, 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 would you entertain a motion for mistrial? We have not heard what he said yet. Let's see if he says it before the judge make his comment. If he says the witness is going to file for a fifth, say a fifth, or did the judge jump to say that before he said it? Let's see.
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke.
He answered the question before Steele said something about invoking the fifth. You notice that? He answered the question before Steele mentioned anything about the fifth being brought up. Do you think that's guilty conscience already? Get it? Did y'all hear that? Steele didn't even mention it yet. He asked, what is he going to invoke the motion for? And then he says, we did not know he was going to invoke the fifth. Did y'all get that? I'm just bringing stuff to you guys' attention because I was, when my little sis sent me this clipping and I was going by the motion that Love put in, and I was going like back and forth trying to figure out what's going on. It's not matching. It seemed like people, because it's obvious what the motion was for, mistrial. No, it wasn't obvious. It wasn't obvious and I know, Rob, you come in here to ruffle my feathers, but I understand. But I'm just saying, you said it's obvious. Okay. Obvious to what? He asked, what does this have to do? But then he said, we did not know he was going to invoke the fifth. Why ask if you already know what he's going to say? I'm just bringing out some stuff. You know, I'm very analytical. I pay attention to details, and I'm just asking the question. I'm not saying anything. I'm just asking the question. I'm just getting y'all minds to just to think a little bit. Not go by what people say, but think. Use the brain that God given us, Pay attention to the details. Just pay attention to the details. That's all I'm doing. Invoking some thought process for you guys. I'm a numbers person. I'm an analyst. I analyze things. Pay attention to details. That's just me. Okay? And I'm just, bringing some things to you. And I'm not trying to sway anybody to anything. I'm just letting you guys see some stuff. Because a lot of you guys watch these videos and you don't have time to pay attention to the details. You're looking at things as real time and not taking time to go back. That's why we have to go back and look step by step of what actually occurred, what was going on, what stuff is happening, you know? And that's why I'm just giving y'all, and I know people in the chat getting defensive and stuff like that. I'm just getting y'all to let your mind just think a little bit, you know? Just don't go by what people say. See it for yourself. Observe. Observe. I'm not here to sway anybody on anything. Troy, if you want the video play, you know what you could do? You can go straight on to Law and Crime and pick up the video at 4:26:46 and call, and then you can go have a good day. Talking about play the video already. Go ahead. Go. Bye. Bye. Go to Law and Crime and get that video at that time. I gave you the timestamp. Don't do this. Don't come in here with that mess. If y'all know me, I'm very analytical. I will go and play something over and over and over, okay? So if you're coming in here, you don't know anything about me, I suggest that if this is not good for you, go find another channel to watch it so you won't be annoyed with me going back and forth on something. How about that? Okay, let's go back. To those that are just coming in, I'm just bringing some attention to some stuff that I took some time today, and I was paying attention to some details. And I was like, how did they know this? How did they know that? And that's what I'm doing. Some people are irritated because I'm a person that's going to take time and going to repeat stuff, going to show you stuff. And if some people have lack of patience, they can go on and have a good day. Okay? But that's what I'm doing, Tasha. Because let me tell you, half of the people did not even see Love look at Steele and Melnick talk to Steele. Half of you guys didn't even see that because you're always watching other things. I'm just bringing stuff to your attention because it's something she put in the paperwork. I'm just that detailed, okay? All right, let's go back. We were talking about the judge jumped the gun after he asked Steele, what is this motion for? And then he interjected that we did not know. We did not know that he was going to plead the fifth. Okay? Okay. Let me go ahead on and repeat this. Hold on a second. Y'all, all those that's coming in, if you want to see what happened, we go ahead and replay it. But I am over here at this point where the judge is asking Steele what his motion is going to be about. But prior to Steele getting up to go over to the podium and giving his motion, the judge interjected and said, hey, we didn't know that he was going to plead the fifth. But we know that is an incorrect statement. You know why? We know it's an incorrect statement because prior to us we were sitting inside the courtroom. We was pulled out of the courtroom, and we was told by the deputies of the courtroom that we are not to film Woody being arrested. Okay. George was upset about it. He asked why, because his Rules 22 says he could take pictures while the proceeding is going on. So George asked to speak with the staff attorney, which is Mr. Wesley. He talked to Mr. Wesley. Mr. Wesley and George asked Mr. Wesley, can the judge put it on record? And Wesley said yes, he would put it on the record. And that never happened. This happened. Okay? All right, let me go ahead and play it. Now, Steele is going up, and then the judge, hold on, let me just go back a little bit. Hold on. Let's go back a little bit. Okay, let's go do this. He's being arrested.
Monday.
And then, Your Honor, the jury is excused. Would you please entertain a motion for a mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going
See that? He said, we didn't know he was going to invoke. We didn't know what he was going to say. Still has not said anything what the motion is about yet.
to testify to. And I certainly didn't let him, he was only asked one question. So at this point in time, there's really, I mean, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case.
Okay, he said that didn't happen in this case. Did you hear that? He said it didn't happen in this case. But actuality, it did happen. Because we all knew.
Thing we heard from Mr. Colton was he was going to testify.
So everything you say, I'll adopt because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr.
Look at her face. Look at Miss Love's face. Okay? Look at Miss Love's face, y'all.
Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. I mean,
Okay. The judge says what I was told. But the deputy told us that the judge told us not to film. So who's not telling the truth here? Did the deputies in the state do something and the judge did not know?
I mean, the last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt.
The parties knew. Okay? The parties knew. Both parties knew. Defense knew. State knew. Because it was in the hallway. He was saying it. Parties knew.
It prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No,
So,
the jurors have heard Kenneth Copeland.
and as well, okay.
I opened on him that he's the killer.
Okay, see, the judge, I would have not said anything because he said that all they've been talking about is Casey. Nope. An opening argument. They called Kenneth Copeland his whole name, did they not? An opening argument. They said his whole name. If I was judge, I wouldn't say anything. I would just listen. Because all of this is going to be replayed back.
We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then
Here's the thing. We knew Love and Hilton knew for a fact because you see how she got ready to say that he wasn't going to come and then turn around and the judge saw Copeland coming in. She knew, y'all. She knew. They both knew. Because I knew. And I'm just an observer. I knew. Everybody knew. Everybody in the courtroom knew. I'm talking about between the defense, the state, the media, the deputies. We knew. Okay? Because, George even put it in his paper, in his motion. I mean, in his article about us knowing.
in your honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial because.
Okay.
Okay.
All right, sir. Thank you. All right.
Your Honor, the rules of that.
Yes, sir. It would apply to everyone.
Now
Yes,
listen to
Ms. Love?
Your Honor, I'd just
Look.
like to put some things on the record
Sure.
regarding Mr. Copeland. As we stated earlier, Mr. Copeland has,
I don't want to interrupt you. Your Honor, I'm just telling the court, I am not accepting the proffer.
Your Honor,
Anybody can
if I
testify.
may,
Okay, but counsel
May
gets
I-
to proffer, Mr. Steele. I can accept that. So could you sit down at that time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court, the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after.
See, that part was a lie. Did you see him say, I tried? Miss Love? Did you see him say, I tried? I didn't see him say, I tried, because we didn't even see what he said.
Mr. Melnick attempted to assert for Mr. Copeland. Mr. May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the director.
Now that's a lie, because when Copeland was on the stand, my camera was on Mr. Melnick for the whole time. She said when Copeland was on the stand, Mr. Melnick was motioning or whatever to the defense. That's a lie, because I have footage of what Melnick was doing at the time. You guys, I showed you guys.
Direction of counsel for the defendants and motions like, that's it. Then, upon information and belief, as we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any point in
Mr.
time tell you?
Copeland,
Does he at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
no, as what happens as Mr. Copeland
That's a lie. That's a lie. That's a lie. The judge just asked her that at any time that he said he was going to invoke the Fifth. She said no. That's a lie. That's a lie, people. That's a lie. It's a lie. Because we even saw it on the little my live. We saw it on my live. Hold on, y'all. Let me pull it up. Hold on. We gotta show proof of that. Hold on. We saw it on my live when I was live during lunchtime. What Copeland said, what he posted on his IG that day. Hold on, y'all. Hold on. Let me go back. Hold on. This is the time for us to rewind. Hold on. While I was on lunch on that day, we have proof here. Thank God for social media. Thank God for proof. Hold on, I'm pulling it up, y'all. For date 87, for my live, my lunchtime live, recapture live break for that day. Hold on, y'all. Hold on. Okay, here we go. This is when I was live during that time. We're going to stop this for a minute. And all those who's impatient, who don't want to see it. Hold on, here we go. Let's go here. We were live on lunch, and I said lunchroom drama. That's what it was titled. Lunchroom drama. We were on here. Listen, we're going to go towards the end because somebody said that Copeland was on his thing. Hold on. It's on them. You know what I mean? They're not doing what he told. He's not doing what they told him to do. You know, that type of thing? Like you're going to force him to do something. 222, J.E. answered that question. Hold on. This is right before I got off. 258. That doesn't make sense. Drake is posted stuff, y'all. Hold on. This is when I get the post about him saying he's not going. Watch. He's going to plead the fifth. Wait a minute. Somebody. Wait. Woody's watching me? Hold on. This is the same day. Oh, wow. Woody's watching me. Surrounded by 50 police, these hoes act like I didn't just come in here on my own. They won't let me move as I was running. Oh, Woody's posted stuff, y'all. Y'all, Woody's posted stuff on his channel, y'all. What in the heck? Woody. Oh my God, y'all, Woody's posted stuff. This is my last jail time. I love y'all, and I have to take this trip. Oh, he just posted it. So he's going to jail, y'all. He's going to jail. Woody is going to jail, y'all. He just posted it. He says, this is my last jail time. I love y'all. I have to take this trip. My head high, nobody. My head high, no. Take this trip. My head high, nobody didn't force me to, and I'm gonna be okay. God didn't bring me this far for nothing. It's what it is. I'll be okay. So he's going to jail, y'all. Breaking news. He's going to jail. So y'all see, I didn't lie. I didn't lie. All those would be trying to act like I lie. I didn't lie. I don't. People just be saying that I don't know what I'm talking about. That I don't give the facts and all that. I told you. I heard the man in the hallway what he said. Okay. Thank you. Thank you for the information. Somebody just see how y'all do me. You see how y'all do me? You see how they be talking about, oh, she's a liar. Because I be bringing up stuff because they don't know nothing about it. But all of a sudden, I'm a liar. I'm in the courtroom for a reason, y'all. Because I hear things. I see things. Some things I might not say it properly. But trust me. Thank you. There he is. Isn't that what he got on, y'all? Isn't that what he got on? I told you what he said, y'all. I told y'all what he said. I told y'all. He's going to jail, y'all. He's going to jail. He said it. He's going to jail. I'm not laughing, but because I told y'all what I heard in the hallway, what he said, and then all of a sudden somebody sent me something that what he's doing, because he's still standing in the hallway over there. He's still standing in the hallway. So he didn't even eat lunch. He's going to jail. This is before we came back. He said he ain't crying. I'm telling you, he looked like he was crying. I saw his face. He looked like he was about to cry. That's why I saw. Maybe he was upset. And that's why, but he's going to jail, y'all. The proof is thank you so much, my trusty person who's in his chat, who sees him. Yeah, he's going to jail, y'all. He's going to jail. He's going to jail, y'all. Thank you, Danny. He's going to jail. He's going to jail. So we just wait for him to get his attorney to announce it to the judge. And he's going to jail. So I got 4 minutes to get back. Okay, because you know they're gonna start on time. So we're gonna go back. So don't forget tonight, I will give you guys a breakdown of everything. I'm gonna tell you stuff that's happening behind the scene that you don't see on the camera. So make sure you guys subscribe, share, let folks know that I'm here, let them know that I've been here from the beginning, and some of you guys just seeing who I am. But I'm the real deal. I promise you, I'm the real deal. I'm in here every day. Ask my peeps. They'll tell you. Y'all just seeing me for the first time in your life. Okay. Now, all those who saying that the state did not know, let me tell you, the state was standing right there when I heard it myself. He told that lady with the pretty lady he told them. Hilton went out in the hallway too. We were all there. We heard it. And the deputy even told us not to record. So stop it with that. Nobody knew. Yes, they did. They knew. Did you read George's thing? Come on now. Stop it. Stop. 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 Stop it. Oh my Lord. Go back. Y'all keep making up stuff. Stop making up stuff. It's facts. It's proof. So stop it. I don't care. You know what? Let me go back to this video here. Hold on. Oh, they all knew. Okay. Let's stop playing, y'all. Let's stop playing. Okay, here we go.
Requested to speak with the state. Mr. Melnick keeps going in regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses, this particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks. And after Mr. Copeland has communicated to this court, he will testify. So watching the goings on as Mr. Copeland is not on the stand, it has been publicized, it has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interests he's representing. And so we would ask that, you know, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person. And I don't know, I guess they're, you know, I don't know what's going on, but I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. And I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interest of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial at the very least. And if it goes any further, find that actions by people other than the state have led to us being where we are, because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch, because now he's been told he's going to be hammered by his attorney. I guess he told him that I guess the state's going to hammer him. I don't even know what, but Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking cordially with one another. And this idea that somehow someone is entitled to mistrial as a result of this action on the part of Mr. Copeland is a farce under these circumstances. We'd ask that the court deny the motion.
All right. I'm going to deny the motion for mistrial, Mr. Steele, at this point in time. I'll note that you've made it. I'll let Mr. Melnick in just a second make whatever remarks he wants. Do you have anything else you want to say?
Yeah, I would like, but my understanding is, I'm going to proffer this. But there's a great investigator who is looking at me and I trust her. I'd like to call her as a witness. I was told, I was not there. I was told that, and I forget her name. I know her first name, but her last name. And Investigator Long, and I may be wrong, heard Mr. Copeland prior to coming in to the courtroom, almost immediately prior, state, and I'm reading from Mr. Kokomo, if I have to go to jail, then lock me up. And then the Honorable David Botts told me as I was walking in that he heard, he's right behind me, so he should
We
speak for
all
himself, but
heard.
he
We
heard
all
Kenneth Copeland tell the prosecution, if I said the wrong people, please correct it, that he's invoking the Fifth. That's why I raised it. I'm not saying anybody did anything wrong. I'm saying that if a party knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury, we avoid that at all costs.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been some behavior that probably wouldn't pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements. Okay.
Well,
So
I'm
going to.
reminded all the time because I live them. I'm just telling the court that in order for you to deny my motion for a this was bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time. Okay. In terms of this motion for mistrial.
Well, I'd like to call the witnesses, but I understand what you're saying.
I'm not going to call any witness. I don't need any witnesses. Your proffers are fine. Okay.
May I add a property line?
Yes.
As you know, we are in a side room off the hallway on the first floor. That's where defense counsel, it's kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach. And I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state.
Thank you.
I believe agents from the state were present
Yep.
within earshot.
Yep.
And that gentleman on the phone, who was Kenneth Copeland, was making it.
How do you know it was on the phone? If it was Kenneth Copeland's on the phone, was he talking on the phone or?
He's standing in the hallway,
Hallway.
10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular
He's saying,
purported conversation.
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business and I was
Okay,
having
but
no interactions with
okay,
him.
but here's the thing. I think it's consistent with I'm not testifying. Okay, he can make a decision not to testify. Okay, but if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is.
I believe that the state was on notice that something like this was going to
Okay, all right, but all of you have kind of, like I said, either unwittingly or I just remind you, from outside agitation or otherwise, you all need to stay away from any of this. You do, both sides need to do this. Do not let outside influences, influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. I mean, these witnesses will testify to whatever they're going to testify to. So
The defense has done nothing.
I didn't say you did anything wrong. Okay, but I did.
I've heard is that the state.
I didn't say you did anything wrong, but
I understand,
Okay.
Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
are we going back to that again? I thought we.
I don't know of any
Okay.
defense counsel that's had any conversations with Kenneth Copeland at all. And I just want to make that clear. Today, I don't know of anyone that's had conversations with.
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer, and that lawyer can make that decision, and so can Mr. Copeland. So
Side situation because we have
I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you. Okay?
Okay.
All right.
Judge, I would like to hear.
Yes, sir. What is it you'd like to tell me, Mr. Malnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year, where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal. I
don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507." They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you probably, and I know you have known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that as you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with him, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is it your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Ms. Hilton and Ms. Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland.
Your Honor.
About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
When did you talk to Mr. Copeland?
last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did.
Y'all, that was rude. Did you see what Love just did? Took the mic over there while a man is standing there. That was rude. That wasn't nice, Miss Love.
Did not want to speak with us. We did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home. And then yesterday he came back down here with us. Again, we showed him some of the evidence that we were going to show him. And that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney. And Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client and then my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But whether or not.
And Your Honor, it's my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where or you come cross purposes with the rules, okay?
Of course.
I mean, so, and that sometimes has to be explained to witnesses and clients, okay? All right, so that's where we are at this point in time, is that Monday morning, I will bring Mr. Copeland back out. It is, I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up, because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial. Because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday and we'll see where we are at that point in time.
Okay.
And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case, okay?
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. This is something I can take up off the record.
Look at them both.
Well, I kind of have to call him on Monday. I do.
You see that? Both.
I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there's nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Judge. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing. If you're asserting, if the state was relying upon the fact that you were not his counsel, and now you have put us in a situation where now you put yourself in between a rock and a hard place. I mean, so he's coming back on Monday.
I'll have somebody else make my
then that can be done. And sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that. So we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is.
I'll have somebody go.
And I need to know who that lawyer is. Do you want to have a conversation with him before?
I'm gonna talk to him right now.
All right. Okay. I'm going to allow you to do that. And then I'll remain and be available for a further discussion. So let me go ahead and Sergeant Ham, can you and your colleagues or Lieutenant Walker arrange for Mr. Melnick to talk with Mr. Copeland, please? All right. And I'm going to go ahead and at this point in time, summon our jurors, please. All right.
All right, guys. We're gonna watch this to the end because someone had brought it to my attention that at the end, Love had asked for ex parte. We're gonna see where that is said. So thank you, Tix, that just said to let it play to the end. Yeah, I heard about that. It was said, but I had not heard it myself. But we're gonna listen together, okay, y'all? Kobe, you going outside? I'll take you outside in a minute, okay? I was talking to Kobe, y'all. Sorry, I was talking to my fur granny. I was talking to my fur granny.
All right, thank you, Sergeant Ham. Promoted already again. All right, okay. Ladies and gentlemen, jury, good afternoon. Okay, it appears that we have some more homework to do, and given the fact that that needs to occur, my suggestion is that we go ahead and recess you for the day, okay? And let you begin your Friday.
No, they hadn't had the ex parte, DJ. This is before the ex parte. This is Friday the 7th.
Ladies and gentlemen, Monday being a regular work day, what I'm going to have you do is report for 8:30 for a 9 o'clock anticipated start time. And we'll see where the day leads us on Monday, okay? All right. Any ministerial
Ex
inquiry to me,
parte
ladies
is
and
on
gentlemen?
Monday,
Anyone?
DJ. Monday.
Okay.
10th.
All right. All right, unless you have anything of me, ladies and gentlemen, let's go through your admonitions at this point in time. Remember, leave your notepads in your headquarters, the jury deliberation room. Please don't take them with you. Remember that as you leave here and you gather, even outside our presence and hearing, to be in your headquarters, or as you go to whatever conveyance that takes you to your home within our great county, or if you're just in the halls eating or whatever, remember that it would be a violation for you to discuss this case amongst yourselves in ones and twos, or handicap the testimony, review the testimony, or otherwise give your thoughts or impressions about any witness that has testified thus far. Remember, you can only consider this case probably when the court gives you at a time and place instructions on how to do that. You cannot consider it in any way until such time as the court instructs you. Remember, it would also be a violation for you to add to your understanding, as I call it, meaning phone a friend, get a resource book, go to a website, or any other source that to aid you in anything that you've heard thus far in this courtroom. Remember, you can only consider what's been lawfully presented within the four walls of this courtroom. You cannot consider any outside sources, people, or otherwise reference materials to aid or augment your understanding. The other thing you cannot do is to go by any scenes that you may have heard about or may have been testified to in this case. You've been shown a bunch of maps and other audiovisual aids at this point in time. You are not to go by and visit any of those scenes. You're not to go by and take any pictures, do any sketches or anything like that, or share any other information you may know about those particular sites that you may have knowledge of. Remember, you can only consider what's been lawfully presented within this courtroom, okay? All right. Also, ladies and gentlemen, if any third party or would attempt to talk with you, reach out to you, email you, text you, or otherwise call you in any way to potentially reach out and communicate with you about this case, remember you to let myself and Sergeant Ingram know immediately. And then, ladies and gentlemen, and lastly is how we end most of our admonition sessions. You know, we are really appreciative of the patience and attention that you've given to this particular matter, and we'll continue to give to it. And we state that to you, and we ask that you. Every day we tell you this, but that is on behalf of all the parties here, ladies and gentlemen. We really appreciate your patience and attention that you have given and will continue to give to this to the consideration of this matter. All right, ladies and gentlemen, unless you have any other inquiry of me, we will talk with you on Monday at 8:30 and for an anticipated 9 o'clock start time. And then we'll see where the week leads us at that point in time, okay? All right, unless you have anything else, all rise. Okay, ladies and gentlemen, our jury has left us. Please be seated. All right, anything else I need to take up with you all? I'm going to recess in place to allow Mr. Melnick to finish talking with Mr. Copeland and find out if he or somebody else at his stead is going to be here on Monday. But if not, we will be here on Monday at 8:30. Any other things I need to consider?
Yes, Your Honor. There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file. We received something additional on a thumb drive last night. We had the deputy of our jail call unit look at that, and we are again missing. We do not have the complete file.
To be able to play
to be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it. We were provided last night a thumb drive with cut and pasted file names up under headings, with some additional pieces of a file that would have had to, again, have been deconstructed from the way that the file would have been given to Counsel for Defendant Williams. We are asking the court to compel defense counsel to turn over to the state the file in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what? And if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glam,
Sir.
you allow another moment when Ms. Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation, just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful, I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8, after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got.
from the Fayette County Jail. There's been no deconstruction. There's been no purposeful exclusion. This is not the first time. And I
Okay.
apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the
No,
hominem
I'm
attacks? Really,
speaking.
could we strike that?
Okay, hey, everybody, calm down, everybody.
This is me
Both of
false.
you, both of you, please be seated.
Judge, I'm not
Both of
done.
you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire. Jury after jury, you did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say, that's not my recollection after I said it. You did nothing. We start the
Okay, but
case.
Mr. Steele.
I asked you, please.
Mr. Steele,
Please, Judge,
Mr.
how would you feel if you were being treated like
Mr.
this?
Steele, Mr.
Well, I'd
Steele,
like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor of another member of the bar. I don't talk with Miss Love. And that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Wrong, though.
But there,
And Mr. Williams, to me, this is an innocent man. You talk about, Miss Love said there's a man in the Fulton County Jail who shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw.
I object to
Now
the
it's
ad hominem
Mr.
attacks, and I ask
All
you to
because she wants to
Again,
win the
from the
case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by the way, to the state October of 2023. October 2023, that was uploaded, given to the state. I hear about it now, and I wait there, and I give them the exact duplicate of what we have. And now there's a false allegation of misconduct.
but
And what I'm telling the court is what I said again. I do not appreciate it. And you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false representation.
Your Honor, again, the ad hominem attacks, Your Honor, I object, and he should stop talking when I object.
Oh, she said he should stop talking when I object.
But Mr. Steele, here's the thing. Okay, I think that, Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Please be seated, sir. Sir. Please be seated.
Whatever you do is fine, but I care about Jeffrey Williams. That's it.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address
He
the
needs to shut up when she objects. Oh my!
I know that at times tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal and rigor. However, I agree that there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial, and so not only for the purposes of this, but it sends not the message I think you want it to send. All right, so I'm going to leave you all to your wise discretion in order to do that, but and I'll take up whatever I need to take up as I see fit. But I know that you all. This has been a long trial. It's very demanding, exacting, and grating on and tiring on all of you. So I ask you to just take a couple deep breaths and step back and see and kind of look at and just remember that you do represent of who you represent and what you're here for. In terms of the tape or the phone calls from Fayette County, it's the court's suggestion that, and if you want my assistance, I can always, with a proper subpoena, have the raw, whatever it is that whatever you're seeking to get, I could get that, and you can compare that against what you have. Because maybe that's what, I mean, and Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence, and I assume that that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms. Love is in her argument is saying that she is, when it's stripped down, less all the sound and fury, she's saying that particular type of file has other things with it. I don't think you were given those, and that's what she's trying to get. So I'm in no way blaming anybody in this circumstance, but if you want that particular file, and I think you all should have that particular, the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you, because nobody probably wants to come down here and see me. So I will work with you all to get that, and you all we can take that up, and it's a problem I think can be resolved. But I'm in no way. But I would just remind everybody to be careful about what they say to each other. Some things you just can't take back, and remember, y'all are going to see each other over and over and over again, and you know it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I've just told you. All right. So I'm just going to recess, and we'll see where Mr. Melnick is at that point in time, and then we'll I can talk about Monday for certain. Okay. All right. Okay, I'm just gonna recess in place. All right.
Okay, this is almost the end part.
Okay. Okay, counsel, is anything else I need to cover with you before we recess until Monday?
Got it.
Yes, Mr. Botts?
Oh, they go
Mr.
bot.
Botts, you need to
Go
use the
bot.
microphone, sir.
They go bot. They go
Is it
bot.
working now? Can you hear me fine?
Yes, sir.
All right. Your Honor, we started this whole fiasco out with whether the state knew that Mr. Copeland was going to take the Fifth Amendment when he took the stand. And if so, was that proper or improper to put him up on the stand knowing that they were going to?
You have to speak up, sir. And if you could hold the microphone, it'd probably be better.
That he was going to assert the Fifth. And I know that they did know that he was going to take the Fifth, because I heard it said outside right before I walked into court. I even said, the officer.
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Well, that's fine. I mean.
I got a problem with you now.
Well.
I would suggest you don't say anymore.
I've already said it.
I know that, sir. And the problem is, you should have told me. If that were your case, then you've just made an argument we didn't even need to have, because I could have certainly asked him based upon your proffer.
Yeah.
Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that, and
that's not what the point is. The point is, you as an advocate, is you should have told me.
You said I already did.
Both sides have an equal responsibility under the rules, the professional responsibility.
Okay, as long as we're both responsible, that's fine.
All right, have a seat, sir. Thank you.
that okay?
No. What's your request, sir?
So in the attempt to avoid any spurious allegations moving forward, I would ask that Your Honor order that the deputies transport Mr. Copeland to the jail completely separate from any.
Yeah, I was gonna, thank you for reminding me of that. In our
also be
order,
found-
wait, just 1 second. In the order of the incarceration, I'm going to, I also have a keep separate order for him.
Your Honor.
For the transportation and the housing, because none of these gentlemen are going to say anything to him, but I don't even want anyone to claim that
Okay.
they did.
I think that that's fair enough, and that's a good suggestion. All right.
We'll prepare, yeah,
Yes, Lieutenant Walker. So that will not be an issue? Okay. Okay. But we'll go ahead and have him, if you could also have him housed separately too? Okay. Okay. Thank you. Thank you, madam. All right. Anything else, councils? All right. Take a couple deep breaths this weekend, take a knee, and come back on Monday and let's get after it again. Okay. All right. We'll see you on Monday morning at 8:30. Okay.
Can you get us the list of names and then any exhibits for Monday?
I think the only, I don't know who is being called. We can find out. Ms. Lovett and Ms. Hilton and Mr. Atkins, who is going to be called? Let's assume that Mr. Copeland invokes again.
Your Honor.
Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland. And there are certain things that have to take place before we can tell them anything. So
Okay.
we need
Fair
to,
enough.
we have to do that. We have to deal with that and where we are right now.
All right.
And that's just where we are.
Okay. Well, be thinking about what scenarios you'd like to have the court look at,
Yes, Your Honor.
depending upon whether or not Mr. Copeland decides he'd like to invoke his privilege again. Okay.
Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam.
Mr. Sharp, he can have the floor.
Yes.
Could I'm just going to ask a courtesy of the deputies, could we just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends? The attorneys would like to have a discussion with our clients.
Lieutenant Walker.
And Your Honor, the state has a matter we need to take up ex parte with the
Okay.
No,
All right.
there it is.
Lieutenant Walker has been asked
There it
by
is.
defense counsels as a corporeal body for them to be able.
Yeah, ask. You did say it, y'all. She did ask for ex parte. Let's play that part again. Hold on. Hold on. Here we go.
Along with their clients. Okay.
Hold on.
Oh yeah. Once we go down.
Okay,
Yeah.
I'll make that happen.
Okay.
Thank
All right. Okay.
you. Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam.
Mr. Sharp, he can have the floor.
Yes.
Could I'm just going to ask a courtesy of the deputies, could we just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends? The attorneys would like to have a discussion with our clients.
Lieutenant Walker.
And Your Honor, the state has a matter we need to take up ex parte with the.
Okay. All right.
The state has a matter we need to take up ex parte. So, wonder what that matter is. I wonder what the matter is. To have a plan for Monday. Okay. With the court. Yep. Texas Black Diamond. Yep. With the court. Ex parte. Yes, she said it. She said it. We heard it loud and clear. She's talking about Solo and not Woody. She said with the court, not Woody. All right now. Y'all heard it. Y'all heard it. Okay. So, okay. Hold on. I was going to show you guys some other part. Hold on. Hold on, y'all. It's not done yet. Hold on. Okay, so we saw the video that she talked about. Copeland cheekily answered a few questions and then invoked the fifth, right? Now she says that she talks about the meeting on June 10th, right, regarding the contempt proceeding initiated by Copeland upon motion, blah 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 blah, and then she tells who was in there: Kenneth Copeland, Honorable Jeff Glanville, attorneys of the state, but she didn't even mention everybody else that was in there. Okay. Then she said, prior to Monday morning, we read all that, okay? But here's what I wanted to show you guys. Okay, we read that yesterday. We read all of this part yesterday. Now, here is the email that was sent on June 7th from Melnick. We read that, right? And then after that, you have March 3rd. You guys see that? 2023. And this is when he's talking to Miss Rosser, right? This is from Attorney Melnick, right? And Sheila Rosser. It says here, Dear Miss Rosser, the state asks that the defendant be required to sign the condition in front of a notary or a sheriff official so that we can enforce the condition upon his release, since he was not apprised by the court in person. Okay? So this is showing that he was his attorney in March 3rd, 2023, which is just showing that Melnick was his attorney, right? The court is waiting for Mr. Melnick's response, right? Then Adrian Love sends a message and proposing a bond order, right? So they're giving him a bond to get out of jail from the time he was in jail. This is what Attorney Love says. She says, Miss Rosser, please find attached the proposed bond order agreed by the state, right? And who? Mr. Melnick. I'm attaching in Word format so that the court can revise when necessary. The two orders have only one distinction. One contained the curfew provision that the court originally ordered, and the other does not. The state does not object to either, and Mr. Melnick asks that the curfew provision be removed. I have explained to Mr. Melnick that since the court originally ordered the curfew, the court must decide whether or not to keep it. Other than the curfew, Mr. Melnick finds the proposed order acceptable. Please let us know the court's decision, as part of the order contains a requirement for the defendant's signature acknowledging his understanding of all the provision and restriction of the bond, and Mr. Melnick will visit Mr. Copeland to obtain his signature this week. Have a wonderful evening. Okay? And then Miss Love sends a mess. No, this is the original one. This went backwards. Okay. So that's that. So that means that they were aware that Mr. Melnick was his attorney, because they had him to take the what do you call it, subpoena, so he can sign it, and so he can be a witness for the state. Okay. And this here is the ex parte motion to compel. And that one was done on, do you see a date on this one? I don't see a date. We can, let's see, hold on a second. I was looking for a date on that particular one. We can read that also. Okay, let's go to this one here. Okay, it says ex parte motion for order to compel testimony necessary to the public interest. I think we read this one already, right? We read this one on June 10th, 2015. Did we read this one? Somebody tell me if we read this one. Where it talked about Donovan was gunned down. Did we read this one? I just want to know, did we read this one? We never read that one. Okay, we need to read this one, right? Kimberly said no, we didn't read that one. Time said no. Let me see if everybody said no. We never read this one. Okay, let's go ahead and read this one. I know I read it for myself, but I don't know if it was read in here. Did Liz want to come and read it? Liz, you want to come and read this? Let me put my link in here. Did you want to come and read it, Liz? Are you still in here? Here's the link. And it's on page, what page am I on here? Hold on, y'all. Hold on, let me make this bigger. Let's make this bigger, bigger. It's on page, mine don't have a page on it. Oh, it doesn't have a page on it. Oh, page 16. Yeah, page 16. Hold on, we're waiting for Liz. Here she come. Oh, Edward. Hello, Edward. How are you?
I'm good, thank you. How are you, Miss Sylvia?
I'm doing fine. You coming
Thank
up?
you.
Hmm?
Yeah, I want to say, like, first of all, from like speaking from everyone else's perspective, I want to say thank you for like clarifying everything that's going on in this trial.
Thank
Because
you.
honestly, like, it really helps us. Like, a
Mhm.
lot of people that don't have law degrees, but they act like they have law degrees. They try and act like they understand it the when when it's going on in trial, but when you break it down, it really makes like everyone else understand for real. So I want to say thank you so much for that.
Thank you. Thank you. Thank you, Edward. I don't have a law degree, trust me. I just like being a teacher.
No, but it's definitely like appreciated though, like still like because you actually break it down and put attorneys on and bring them on and explain everything that's going on. You know what I mean? And I know like the lead attorney and all of them, and I'm not trying to promote anyone else, but they all do very good. But probably you are probably one of the best, honestly, because
Oh,
just from having you break everything down by yourself, you don't even need a lawyer. Like if you're not an attorney, you do it very well at breaking everything down for us. So thank
thank
you.
you, Edward. Thank you. Thank you. Oh, you've just made my heart happy. Thank you.
Yeah, no
All right.
worries.
All
All
right.
right, so you want me to read this?
If you want, well, Liz came up to read. She's up here now.
Oh,
I mean,
okay,
you can
Go
bet.
stay
ahead,
up. You
Edward.
can
Go
stay.
ahead. You start. Go ahead.
Are you gonna
I'm
read
right
Okay.
that,
here.
or do you want me
Go
email
ahead.
it to you, Edward? I can email.
Uh, yeah, you could email it to me. To be
Oh,
honest,
let me do that.
that'd be,
Cause it'd be easier for you to read that way. Hold on a second, Edward. Let me stop sharing it for a second. Let me send it over to Edward.
sorry to cause the extra time.
Edward, go into the private chat and put your email in the private chat, and I'll go email it to you.
All right. Chat with everyone. I think this is.
Yeah, where it says private, just put it in there, and I'll email it to you. Hey, Liz.
I'll send a different email just because I'm using my dad's account on here. So.
Okay, I got it right here. I got it.
This live is fire today, Miss Sylvia.
Oh, thank you. Okay, Edward, you should get it in a second. You should get it now.
All right. Hopefully it doesn't kick me out of this when I open the email. I'm hoping.
You don't have another device?
Yeah, I'm on a mobile. Yeah.
Okay. You should get it now.
All right, cool.
I'm just gonna stay out, Miss Sylvia, to make sure he gets it, and then I'll drop down, okay?
Okay, thank you, Liz.
You're welcome.
Hey, everybody. Just patient. All the impatient people can leave if they don't want to sit and wait.
Hey, I have to say one thing is crazy is like every time I do this now, like every time I wipe my nose, I feel like I'm a part of the gang. I'm not gonna lie, like I feel associated just by wiping my nose, bro. Like I'm sorry, police, please
Look,
don't lock me up.
I was in court. I was wiping my nose in court because it was like itching.
Yeah.
I can't do that.
Yeah, exactly. You have to do it a whole different way. You know what I mean? Like you have
I got to go like this now.
and even if you support a certain side, you have to use your opposite hand just to be, you know what I mean, kosher with it.
Yeah.
That's kind of crazy. But free Young Thug and free Kendrick too. Free Kendrick.
All right, you got it. Were you able to open it up?
Oh,
Oh, we're gonna lose him, y'all.
I'm not on here. Okay. Yes, it's gonna disconnect. So give me 2 seconds, Miss Sylvia. I apologize. I'm gonna pull it up on my computer and then I will read it for you.
Okay.
All right. Let me just pull up my email real quick.
Okay. All right, y'all, as we wait on him to come on in.
Oh.
You got it?
Yeah,
and I want to go to page 16. I think it's page 16. Hold on a second, just make sure.
I received the email, but I'm just trying to make sure. Because when I tried to open it, it said it can't open.
What? It can't open?
Yeah, that's what it said. But just give me a second. Oh, here we go. We're good.
I think we're on page 16.
Page 16? All right, bet.
Where it says ex parte motion for order to compel, that one.
Okay.
It's right after the Exhibit B. Go to Exhibit B, the next page.
16. Exhibit A. All right. Exhibit B. You said 16?
Yeah. Right after Exhibit B.
Okay. So from pursuant, or where'd you say so?
It should say the ex parte. It says ex parte motion for order to compel testimony necessary to the public interest.
I'm on call. Hold up. I'm on call. Yeah, I'm on call. With the person from YouTube. Sorry. I'm trying to find it. I'm sorry, Miss Sylvia. Give me 2 minutes. Exhibit B. It's right after Exhibit B.
Yeah. Next page.
Okay. Okay. I just seen it and then I lost it. Ex parte motion to compel testimony necessary to the public interest.
Yep,
That's what
that's
it
it.
is.
Yep.
All right.
Yeah.
Firearms evidence recovered from Thomas Jr.'s body and from the scene where Thomas Jr. was gunned down, 330 McDaniel Street in Atlanta, Georgia, reveal that the 7.62 rifle and at least one handgun were used in the murder of Thomas Jr. and the shooting of Hendricks and Sanders as well. Surveillance footage recovered from business in the area where the shooting occurred revealed that Thomas Jr., Hendricks, and Sanders were assailed by gunfire that originated from the sunroof and possibly window
Where
of
you
a passenger.
hold on a second. What are you reading? Because I don't see what you read.
That's not the one I'm on?
I don't see that. Yeah, do you see the same thing he's reading? I'm like,
All right,
okay,
so
I don't see the same
okay,
thing.
hold up. Ex parte. So, all right, let me see if I could turn my camera so I can show you what I'm looking at. Nope.
Yeah, I'm trying to figure out what is he reading. Hold on, y'all.
Yeah, I honestly thought I had where you were, because at the bottom of one page it said ex parte motion to compel testimony necessary to the public interest, and then after it goes on to 3, like in Roman Roman numerals. You know what I'm talking about?
Yeah, I see what you're talking about, but I don't see what you're reading. You're reading something totally different from what we see.
For real? This is what you sent me.
Yeah, I did.
So
You went to 3? That
you
okay.
said
Why
you
don't
said
you start
exhibit
with 1?
B.
Start with 1. Start with 1. Roman numeral 1.
Roman numeral 1.
Yeah, start with.
Okay, so on January 10,
There we
2015.
go. Start from that. Yeah, start from that.
Okay.
Okay.
All right.
Sorry, guys. My apologies.
Sorry about that, everyone. On January 10th, 2015, Donovan Thomas Jr. was gunned down and murdered at 330 McDaniel Street in Atlanta, Georgia. Reginald Hendricks and 14-year-old Cordarius Sanders were also struck by bullets during the shooting. The Fulton County Medical Examiner Office determined that Thomas Jr.'s cause of death was gunshot wounds to the torso and determined that his manner of death was homicide. Firearms evidence recovered from Thomas Jr.'s body and from the scene where Thomas Jr. was gunned down 330 McDaniel Street in Atlanta, Georgia, revealed that a 7.62 rifle and at least one handgun were used in the murder of Thomas Jr. and shooting of Hendricks and Sanders. Surveillance footage recovered from business in the area where the shooting occurred revealed that Thomas Jr., Hendricks, and Sanders were assailed by gunfire that originated from the sunroof and possibly window of a passing vehicle as the vehicle traveled west on McDaniel Steel at around 7:22 p.m. on Sunday, January 10th, 2015. In the early morning hours following Thomas Jr.'s death, Kenneth Copeland appeared at the Atlanta Police Department headquarters building and requesting a meeting with police to report his whereabouts during the time of the murder and to report that his family was being targeted by people that, according to Copeland, apparently believed that Copeland was responsible for the murder of Thomas Jr. In the days and weeks and months following Thomas Jr.'s murder, Copeland gave 6 recorded statements to law enforcement, one of which was over 9 hours long, detailing Copeland's involvement with the criminal street gang YSL and statements of YSL co-conspirators about the involvement of YSL members in the murder of Thomas Jr. and other criminal activity. Copeland gave a detailed account of the events that led up to the murders of Thomas Jr., as well as his own involvement in said events and of the events and acts committed by Copeland and other YSL members in the months following Thomas Jr.'s murder. Phone records of Copeland and other YSL members corroborate the statements that Copeland gave to the police. Statements made by YSL co-conspirators also corroborate the statements that Copeland gave to the police. Based in part upon the statements that Copeland gave to the police, 5 YSL members were indicted for the murder of Donovan Thomas Jr., and 28 members of YSL were indicted for violation of the Racketeering, Influenced, and Corrupt Organization Act. In the judgment of Honorable Fonnie T. Willis, District Attorney of the Atlanta Judicial Circuit, the testimony of Kenneth Copeland is necessary to the public interest. OCGA 24-5-507A. Hey, you want me to read this this part like beyond that?
Yes, I'm sorry, I was muted. Yes, go ahead and read
Okay,
it.
no worries. Whenever in the judgment of the Attorney General or any district attorney, the testimony of any person or the production of evidence of any kind by any person in any criminal proceeding before a court or grand jury is necessary to the public interest. The Attorney General or the district attorney may request in writing the Superior Court to order such person to testify or produce the evidence. Upon order of the court, such person shall not be excused on the basis of privilege against self-incrimination from testifying or producing any evidence required, but no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he or she testified or produced evidence under court order. However, such person may nevertheless be prosecuted or subjected to penalty or forfeiture or any perjury, false swearing, or contempt committed in any testifying or failing to testify in any producing or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of this state, the United States, or any other state. Any order entered this code section shall be entered full of record in the minutes of the court, so as to afford a permanent record thereof, and any testimony given by a person pursuant to such order shall be transcribed and filed for permanent record in the office of the clerk of court. If a person refuses to testify after being granted immunity from prosecution, and after being ordered to testify as set forth in this code section, such person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. If the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. Emphasis added. Kenneth Copeland has been subpoenaed to testify in the above styled case. Copeland is the next witness scheduled to testify in this case on June 7th, 2024, beginning at 9 a.m. on June 4th, 2024, and June 5th, 2024. Investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th. However, on Thursday, June 6, 2024, after an encounter with defense team members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the Fifth in order to avoid testifying against members of YSL. Pursuant to OCGA 24-5-504, Copeland shall not be excused on the basis of the privilege against self-incrimination from testifying or producing any evidence required, and no testimony or other evidence required under the order or any information directly or indirectly. 4. Ex parte motion to compel testimony necessary to the public interest. Derived from such testimony or evidence shall be used against Copeland in any proceeding or prosecution for a crime or offense concerning which he or she testified or produced evidence under court order. However, Copeland may nevertheless be prosecuted or subjected to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify, or in producing or failing to produce evidence in accordance with the order. I swear I read this. But shall not be required to produce evidence that we're on the same thing, right?
Yeah, it's the same. Go ahead, keep reading. I think
Okay.
they repeated it.
Yeah. Sorry. In accordance with the order, but shall not be required to produce evidence that can be used in any other court in this state, the United States, or any other state. See OCGA 24-5-507A. Accordingly, the state of Georgia hereby moves to this honorable court to direct Mistrial witness Kenneth Copeland to testify in the trial of the above styled case until released by this honorable court from the subpoena compelling said material witness to appear and testify before the honorable court. Further, should said witness refuse to testify or being granted immunity from prosecution pursuant to OCGA 24-5-507, in order to testify pursuant to OCGA 24-5-507, the state moves this honorable court to hold said material witness, Kenneth Copeland, in contempt of court and commit said witness to the Fulton County Jail until such time as the witness purges himself of contempt by testifying as ordered. Signed by Fonnie Willis and Adrian Love. Exhibit C.
All right, thank you so much. I appreciate it. This is the same thing again. Hold on, let's see. What is this one here? So this is when the judge signs it, right? This is
So,
yeah, this is when the judge signs the order,
Yep.
y'all.
Yep.
Let's go down to D, Exhibit D. Let's see what Exhibit D has on it. Exhibit D has the ex parte hearing, the transcript. We read that already. Let's go keep going down, see what else we got in here.
shout out to Caleb Bumpus too. She's holding it down for real.
Hold on a second, Edward. I'm trying to see what else is in here that I would like you to read, but it's nothing else. Let's see. Because we read these transcript already, so.
Yep. That's all the same.
Yeah.
And like, you know, like from what I just read, like I low key feel like that is a legal way of like bribing a person and telling them, hey, you don't want to spend the rest of your life in jail, so you better testify. Otherwise, you're spending the rest of your life in jail, basically.
Yeah, that's just like forcing somebody.
Literally.
And they don't want to do it.
And like, because they're innocent until proven guilty, they should have the same rights that we do. They don't, but they should. And they shouldn't be treated like they're guilty before proved innocent.
All right, so we got that. That was perfect. Thank you so much, Edward. You are awesome. You're awesome. So look, you know I'm gonna have to start using you too now, right?
Sound good. I'm gonna be in here every time you go live. I get notifications and I see it and I instantly just drop in because I know you always got something to say. And like Seti Nash is not doing it like you. So keep up the work.
Don't be putting me out with other people.
Hey, it's all love to Seti Nash too. Oh God, it's all love to Seti Nash. But you get the info and then Seti Nash like clips it and you know what I mean, reports it back to his channel.
Yeah.
So you're one of the first, like really, like what Weinstein said the other day. You're one of the only people that really takes time and goes out of their way to make sure everyone has the information that they need.
Hey, that's the teacher in me. I've never been a teacher, but I always desired to be a teacher. So I figured out, hey, I use you guys as my guinea pigs.
Hey, I appreciate you, Miss Sylvia.
All right. Thank you, Edward.
Take care.
I'll keep your email on here on Stack. Thank you.
I bet.
All right, hon. See you later.
Take care, chat.
Don't you get us in trouble up in here. Get off. Y'all see what he did? Y'all see what Edward did? He tried to get us in trouble up in here. You see him? He did the sign. He did the gang sign. Oh, all right, guys. That was the end of what we had to show you. The thoughts and the idea, the stuff that the folks do on my panel is not a reflection of me. It's not a reflection of me. Yeah, I'm laughing because, hey, you got to have a sense of humor. You ever have sense. All right, shout out to Dom. Dom is going to be in court tomorrow for Boosie. We're going to bring you guys the coverage from Boosie. Finally, we get to see whether or not Boosie is going to his case going to be thrown out or if they're going to continue with the prosecution of Boosie. So they did modify his bond condition. So tomorrow we will be out in California to cover that. Shout out to my boots on the ground, Dom K. He's going to be out there to bring it to you guys. All right. So let's get back. Slime Edward trying to get us in trouble. I'm not saying it, y'all. I'm not saying it. And then tomorrow night, tonight I'll be on Woke Christian channel at 7:00. Tomorrow night I will be with Mr. Jeffrey William Sr., his podcast tomorrow. I will be with him and we're going to be talking stuff from now. Okay. So I'm about to go back, hang this up so we can go back and finish the case. And then tonight, I'll be with Woke. I'll see you guys later. Bye.